Today we're going to talk about IRAs and how they work in the context of your estate plan, in particular your revocable living trust. We're going to talk about IRAs being owned by a trust and a trust being the beneficiary of an IRA and what the difference is. Now, unlike a home or investment accounts, which can actually be retitled in the name of the trust, an IRA has to be owned by an individual. It is an individual retirement account. So you cannot retitle or make the trust the owner of an IRA. So that's an easy one. So the IRA has to stay in your name. Now, can an IRA be the beneficiary, can a trust be the beneficiary of an IRA? Yes, it can. And so we're going to spend a few minutes in today's video talking about, okay, a trust can be the beneficiary of an IRA. Should it be the beneficiary of an IRA? We've talked in prior videos about what it means retitling your home, retitling other assets. IRAs and qualified accounts are a little bit different. Okay, so looking at should we have the trust be the beneficiary of an IRA, going back to the 3 Ps that I've mentioned in prior videos, which is the reason that you would sometimes look at moving assets into a trust. The 3 Ps are privacy, probate, and protections. Now, the idea behind privacy is it is not public record because it is not subject to probate. So trust assets don't go through probate, and so they are private. And lastly, protections, meaning you're able to set stipulations inside of a trust that says the money needs to come out in this way, in this manner, in this amount. So you get some control there, and you get protections against divorce, and you get protections against creditors. And there's some real value to that with your accounts. Now, inside of an IRA, how does it work? Well, if you were to have the trust be the beneficiary of an IRA, let's look at the first two when it comes to privacy and probate. Well, an IRA is going to have a beneficiary designation on it. And if an account has a beneficiary designation on it, like an IRA or an insurance policy, it will pass outside of probate already. And so while you might want to title your home in the name of a trust to bypass probate, or an account to bypass probate, an IRA with a beneficiary statement, with a beneficiary designation, will already bypass probate and already be private. So the first 2 of the 3 Ps is already going to be taken care of. You do not need to make the trust the beneficiary of an IRA in order to accomplish this. It's going to be passing more efficiently than the probate process anyways. Now let's talk about the last one, this protection. Protection against overspending, against divorce protection, against creditors. Now, the issue that you run into with IRAs now, this is 2024, but currently the law states that with an IRA, it has to be liquidated within 10 years by the beneficiary. And so the trust, if it's in a trust, is going to have to liquidate that account within 10 years. Your beneficiary is going to have to liquidate that account within 10 years. And so you lose a lot of the ability to protect that account over time if it's in a trust. You don't really get those advantages. And so your first 2, privacy and probate, are already taken care of. You don't need a trust for that. And the third, when it comes to protecting those assets over time, you can't really do because of the 10-year rule. And so should you make a trust the beneficiary of an IRA? I would say if you walk through this process with your estate planning team and with your financial advisor, just make sure you're incredibly clear why you're doing this, and it's worth any sort of administrative hassle because IRAs and trusts being the beneficiaries of IRAs can be a bit more of a hassle. Just make sure you understand the trade-offs when it comes to privacy, protection, and probate. I hope you found this helpful. And as always, thanks for investing your time with the Personal CFO.